And thank you all for joining us again on this edition of IPWatchdog Unleashed. This week we have a conversation with a good friend of mine, Jim Carmichael. Jim is the founder of Carmichael IP. He's a former administrative patent judge, which he'll talk to us about here today. And he is also the lead attorney at the firm that has really the best reputation, there's no other way to say it, for patent owners at the PTAB. Each year, Jim's firm, Carmichael IP, is either ranked first or second in terms of their win rate on behalf of patent owners. So Jim and I have been friends for a long time. We have had many conversations about the patent system, about patent litigation, and of course about the PTAB, which is his particular area of interest. And what we're going to do here today is we're going to go through and try and capture all these conversations we've had over the years in light of where we stand today, in order to create a list of things that we think the Patent Office can and should do to make the PTAB process better. So, Jim, thanks for being here with me today. I really appreciate it.
My pleasure. Thanks for having me, Gene.
All right. Well, we got a lot of ground to cover. And the theme here is, what would Jim change? If you were a wizard and can wave a magic wand, you're Merlin for the day, and you're focusing on the patent system, what would you wave your magic wand to do? What's the first thing on your list?
First, I want to say that the current administration is already doing some of these things that we've been bantering around for the last couple of months. Mm-hmm. They kind of got out ahead of us a little bit on some of the ideas that we had.
Well, that's the very first one, right? It's about discretionary denials, really. And it's about, I have for a long time said, and I know we've talked about, the statute gives the discretion to the director to decide, and almost unfettered power, right? I mean, it's not an appealable decision to decide whether or not to institute. And very quickly on at the beginning, that was delegated to the board. And now there's sort of been a half step towards not delegating, towards pulling it back.
Right. So I got to give it to Acting Director Stewart for taking that half step and doing it the right way. The right way is immediately issuing guidelines, or in this case, rescinding guidelines, and putting in place the start of a rule package early on, which previous administrations didn't seem to get that. They were doing guidelines that would be reversed by the next administration, that would be reversed by the next administration, and so forth. But they seem to got the message that they announced just yesterday that they're going to put this in a rule package on this issue of discretionary denial. So the halfway step that she took was to take control over the discretionary piece of the institution decision. The statute says that it's the director that determines whether there's a reasonable likelihood of winning in the trial for the petitioner. And yet, despite that explicit language, we have never actually had that in the AIA. It's always been, from the beginning, as you said, Gene, delegated to the board.
And just to say, there's nothing illegal about that delegation. It strikes me as a little odd over the year. I mean, because the director, there's so many things in the statute, so many things in the rules, so many policy choices in the MPEP. There's a whole chapter in the MPEP about delegation of authority. So the director can't do it all.
Sure.
But I think that there was a whole bunch of us that thought that there should be a different group deciding whether to institute than the group who is charged with deciding on the merits.
Absolutely. That's the confirmation bias that we've always been concerned with, because now, until now, you would get an institution decision from a panel of 3 APJs that have decided that there's a reasonable likelihood that the patent is invalid, and give their reasons, and then they go on to do the trial part. And the idea is that as patent owner, you have to try to make them, reverse themselves, basically. And if you think if it's hard for a regular person to admit that they were wrong, try convincing a judge that they were wrong.
Right.
Yeah.
Well, and the retort to that has always been that, well, this is the way it works in federal district court. The judge decides on preliminary injunctions, and then the same judge decides the case. And my response to that is, well, we're not in federal district court, and that is a big part of the problem. That's been a bone of contention ever since this initially started, that you're not using the Article III courts, you're using the executive branch courts, and these people have not been confirmed. And not to say that they're not qualified. I know years ago I did write that article, and at the time there was a lot of the judges just did not have a lot of legal experience. They would not ever in a million years have ever been confirmed by the Senate to be a district court judge. I think that has changed over the years, and we do have a very good board now, a very experienced board now.
We do. I have to challenge you, Gene, on your idea that in the district court that the judge handles everything. They don't. There's this thing called a jury. And
there's also a magistrate, right? I mean,
sure, yeah.
So just to be clear, this is not my position. This has always been what people raise to me, and I'm like, I think you're comparing apples to oranges. So the district court judges are extremely experienced. They're constitutional officers. We know the PTAB officers are not constitutional officers. There's a whole host of reasons why it's different, and in many of these things, there's a magistrate handling a lot of these issues, the preliminary issues, at a lot of the courts. And the magistrates, I don't know of any magistrate, maybe there is one somewhere, but I don't know of any magistrate that isn't an extraordinarily experienced trial attorney. That's how you become a magistrate.
Sure.
Some of these magistrates have 30, 40 years of experience.
Yeah.
When they get appointed, and the judges love having them because they really know what they're doing. They know the way the courts are supposed to operate. So I don't understand why we can't do something like that at the patent office. So bifurcating this merits versus discretionary denial makes all the sense in the world to me. As happy as we are that this important first step has been made, do you think it goes far enough?
Well, no. Like you said at the beginning, it's a half step. Mm-hmm. It only reclaims half of the institution authority back where it should be in the auspices of the director. Mm-hmm. The discretionary part. The other half, we can call that the merits part, should also be decided by under the aegis of the director. Now, in yesterday's board side chat that I attended, they said that the APJs that the director would consult for this new discretionary denial process would not be involved and would not be the same panel that decides the trial if there is one. And I think that's a great approach, and we just need to put the other half in there, the part that the statute says,
right,
the reasonable likelihood of unpatentability.
And the other thing that's been raised, and then we can move on from this, but the other thing that always gets raised to me is, well, this is about judicial efficiency. There's so much that's done on the institution stage to decide whether to institute on the merits that just doesn't make sense, taking it from one panel and handing it off to another panel. And my retort to that is you're talking about taking away what the statute refers to as a property right. When this first started, it was predicted we were going to have 450 to 500 of these a year. We've had 3 to 4 times that number. It's never been lower, I think, than 3 times that number, or like 2.8 times what was predicted. And it's gone up to very close to 4 times what was predicted in some years. So if what we were really concerned about was the quote-unquote bad patents, and we can have a whole nother long conversation about what that means, but if we were concerned about bad patents, we should go the extra mile to make sure we're only focusing on the bad patents and not taking away the good patents, which, according to the office, the examiners get 96, 97, 98% right every year based on their metrics. And I don't dispute that. There's some examiners I disagree with. There's examiners that don't issue patents. But by and large, I think this examining corps, very conscientious, do hard work. They do a good job. So why shouldn't we go extra to try and get this right?
Yeah. And you know what else? The way it's been done since the AI started, with the PTAB being judge, jury, and executioner, deciding both the institution decision and the final written decision. It gives away power from the elected officials and their appointees to career people, and that may or may not be what this current administration wants.
No, I think they shouldn't. I don't think the last administration should have wanted it. I don't think any of the administrations before them should have wanted this. If I were director, and we all know that's not going to ever happen, because
I would nominate you.
Well, thank you, but I've told too many people what I really think to get confirmed. I mean, I know that. I get that. But if I were director, the first thing I would do would be to pull this back. And I wouldn't be the one deciding each one, but it would be my authority. And I think the way you should handle it is you have like a SWAT team of people who get not only the law, but they get the office. What can we legitimately do? What should we be doing? What are our resource constraints? What are other considerations? And really controlling this. Because for 200 plus years about 200 years at least, of our existence, the position of the leader of the patent office was, we're in the patent granting business. We should have nothing to do with taking them away.
Right.
Now, I get things change, but I don't think that sentiment is a bad one.
I like your SWAT team analogy, but I do find it curious who the director has decided is her SWAT team. It's 3 senior administrative patent judges. And I find that curious for a couple of reasons. One is that right now with work capacity management at the PTO, there's going to be, and there already are, fewer and fewer and fewer APJs available. And so why take 3 of them off production and put them into this process? The number, of course, is being reduced because of the memo that told them if they don't come into the office by yesterday, April 17th, that the other option is for them to leave the federal workforce. And
so you're talking about the memo that has been reported. I haven't seen it, but I know people are talking about it openly. That went out from Chief Judge Bullock to the APJs that I guess told them that there were going to be, or reduction in workforce was coming, and encouraged people to either get back into the office or to take the fork.
Yeah, and then they sweetened it by saying, well, I'll give you $25,000 extra if you leave and take the fork out. But anyway, the deadline was yesterday, so we don't know the total numbers just yet. But the memo implied that it did say there will be layoffs. The number depends on how many people took the fork by April 17th.
Yeah. So I know you say that this is strange in taking them out of production. To be completely consistent myself, what I have said all along is that I think we need to have fewer IPRs. Now that to me doesn't necessarily mean have fewer judges. So what I think, and I think there will be a smaller PTAB anyway, but I'm not in the business of saying you should be fired, judge, you should be fired, you should be fired. What I've always wanted is to have the PTAB spend more time getting it right. You know, really look at these things. Roll up your sleeves, and I know they do a hard job, and they do it mostly well. And my problems with the PTAB is almost universally been on process. There's been a couple cases I have complained about, but I would rather have them, since you're taking rights away, a property right away. What's wrong with spending even more time than you are right now to have a higher confidence, to have more judges look at it? And I know you're going to be taking, when I say have a whole new panel or a couple panels to do the institution, the SWAT team, you're going to be taking people out of production, or you're going to be pulling them from somewhere. And I'm okay with that. If we go backwards to the 500-ish number that we thought, and it doesn't have to be 500, it can maybe be a little less, maybe it'll be a little bit more, but dramatically cut back, really go after the bad patents, and really, really make sure you're getting this right. And I think also giving more process to the patent owner. I think the petitioner has plenty of process. I worry about whether the patent owner has enough process.
Yeah. So that kind of depends on how deep the layoffs are, which we don't know.
Right.
If they cut the size of the number of APJs in half, it's going to be hard to do anything except cut the number of IPRs in half, roughly.
I suppose, although this maybe is a good time to pivot into your next bullet point that I have spent so much time talking to you about, and I know it's a pet peeve of yours, is about the expert witnesses.
Well, can we?
Sure. Is there more to say? Go ahead.
Yeah. The other thing I thought was odd about the choice of her SWAT team is that it's 3 senior APJs that yesterday they revealed might not be from the art unit of the patent. Now, art unit isn't the right word, but I'm going to call it that anyway. They have about 5 maybe divisions, they call it at the PTAB. I was in the electrical and computer division, so that's how broad it is. But yesterday they couldn't even commit to having someone within one of those 5 divisions be deciding the merits-based aspects of the discretionary denial. And so I'm thinking that they could, if they really get squeezed on staff capacity at PTAB, they could bring in examiners to assist with the merits on the institution decision, examiners who are from the precise technology, and they're going to be able to jump in faster, and arguably they're going to know what a posita would understand just because they live and breathe that particular area.
I'm not as concerned about this as you are, because I do think when you look at the list of factors that Director Stewart put out that they would start to consider, she would start to consider with her panel of judges on the discretionary denial part of the institution decision, a lot of those didn't relate to the merits at all.
You're right.
Most
Just one does.
Right.
Only one, but it's an important one.
But it is an important one. But I think one of the ones that really caught my eye was about the settled expectations. How old is the patent? Has this ever been challenged? Was there an opportunity to challenge this in the past? And I think that's going to be a big factor. And that's not one that matters. You don't need to have any knowledge at all about the art to know that, okay, well, this patent's 12 years old. We've had all 3 maintenance fees have already been paid, never been challenged. And now all of a sudden, a dozen people are trying to challenge the patent, or one of the groups is trying to challenge the patent, where they have all these members. You don't need to know the art to know that there's something going on there that should have happened a long time ago. If this was a property right, we would never treat real property this way, ever. And we don't treat trademarks this way, right? I mean, if after a certain period of time there has been no challenge to the trademark, then the trademark is incontestable. Now, I understand if you can prove fraud, there's still that. If the trademark name became generic, then there's still that can be challenged. But once you have an incontestable mark, incontestable means by and large incontestable. And there's trademarks all the time, and there's monitoring systems, and companies monitor them, and they do challenge the ones that matter. We've never had that on the patent side, and they've pushed back over and over again. But why? Why are the patents different? Why should you be allowed to wait for a decade or more and then say, oh, yeah, I know you've got investments in this. I know this settle expectations is this is good. The statute even says it's presumed valid. But now I'm going to challenge it.
Yeah. So some people say that it's a property right. Many people lately don't.
Right.
I'm in the former camp. It is a property right. And so settled expectations fits right in. Like if you bought a piece of property and over the years you built a house on it, and then a barn and an addition, and then somebody comes along and says, hey, I actually own that land. There's something a little bit wrong with that if they took so long to challenge it. And kudos to Acting Director Stewart for recognizing the settled expectations as a factor in instituting. I think she can go further with that. I think she can say, well, okay, the patent is 10, 15 years old. Yeah, that's a settled expectations. But I think she could also consider, well, is this prior art something that the petitioner could have found right when the patent application was first published, or when the patent was issued, or within 9 months of that, and file a PGR instead.
Yeah. So let's move on to number 2, to expert witnesses. Now, did you actually one time have a case where the opposing side had a dozen experts against you?
I did, and I represented a startup, and I was going up against a Fortune 50 company, and the PTAB allowed them to have a dozen expert witnesses on the other side, and obviously, as a smaller company, we couldn't afford that.
That's astonishing to me.
There's no limit. Now, in district courts, as you probably know, there is a limit, and you absolutely can't have two experts talking about the same thing for the same party.
No district court judge would ever allow that.
No, the PTAB does, if you have enough money.
So there's a couple things we got to unpack here. One is this no limit on the number of experts, and this takes the war of attrition that we know goes on to an entirely another level.
Yeah.
It's just a war of money. I'm going to bury you with money rather than pay you a licensing fee that is fair and reasonable based on what I'm using of yours. I'm going to pay an expert to beat you. And not just one, a dozen experts. So there's that problem. Then there's the other very much more fundamental problem. Why do we allow experts to begin with? I thought when we were going down this path, this was going to be, certainly on the institution stage, this was going to be about, we're going to look at the patent, we're going to say, oh, wow, that one probably shouldn't have issued, or maybe I've got real concerns about that issuing. This was supposed to be an institution decision based on the patent itself. And are there obvious flaws? Does it really look like a mistake was made? Do we need another look? And that's not what has transpired.
No, it isn't. And, one great thing about the PTO is it has an amazing repository of talent and knowledge about technology. It does, from the examiners to the APJs. The APJs generally have graduate level education in their field, whether it's computers or life sciences, whatever. So they're about the level of a posita, generally. So they're pretty good at saying what a posita would understand without having a super posita who knows everything say what would have been obvious to him or her, which I think kind of skews it. It's like, okay, so everything's obvious to Einstein, but that's not the standard.
Right.
And there are even examiners that are designated as experts in the technology, and you could consult them if you needed to.
Yeah, I don't understand why we have. Well, certainly I can see no defensible reason to have multiple experts, and I question the necessity to have experts on the merit side, but certainly on the institution side, there should, in my opinion, should be no experts. Period. This is either something that we want to look at or not. And if you can't make your case about the patent with the prior art to the point where it piques the interest of the decision maker on the merits, we should stop right there. Because the statute actually says this document, the patent, is presumed valid. I know when you go back to the patent office, they don't presume it to be valid. We've had that conversation ad nauseum over the last 15 years or so. But the statute says presumed valid. So it seems the burden, it should be a real burden on the petitioner.
Yeah, and the statute for AIA also says that the decision is based on patents and printed publications, not patents and printed publications and expert witnesses. Out the door.
Right.
And so, and I'll tell you from my practical experience, the use of experts in IPRs it adds a lot of cost. It's not it takes away from the idea that the AIA would be an inexpensive alternative to litigation. I would say that the experts increase the cost by at least a third.
Mm-hmm. Then the next one is supplemental briefing. What's your thoughts on that?
Yeah. So this is has been an evolving scenario, but it's gotten to the point now where there's practically a trial before the trial. The institution decision was supposed to be a cheap, quick look to see if it's even worth going into. And that was going to protect patent owners, according to the folks that were pushing the AIA in the first place. That's been eroded because almost always now the petitioner will request and receive permission to have another round of briefing. In other words, there's a petition, there's the patent owner preliminary response. That's all the statute contemplates. But what's happened is there's a full another round of briefing usually where the petitioner's looking at the patent owner preliminary response and noticing, oh, they made some good points. I got to rebut it. I got to strengthen my petition now with arguments and maybe even with evidence. I say that is contrary to SAS, which says that the petitioner is the master of the case, and the petition is what controls the outlines of the challenge, not this supplemental briefing that is going on lately.
Yeah, and let me ask you this. Is it true that the board can decide that these claims, once they're instituted, they will decide the claims as being unpatentable for any reason, not just limited to what's in the petition?
So there's an APA issue there that's been fought out at the Federal Circuit. And the answer to your question is yes, so long as they give the parties a chance to be heard about the new theories that the board comes up with.
And that's different though than the supplemental briefing issue we're talking about right here now.
It is. The supplemental briefing is for the institution decision, and that is usually limited to what the parties say in one of these iterative supplemental briefing rounds. So my proposal to the director is to eliminate supplemental briefing, stick to what is stated in the statute, the petition, and the patent owner preliminary response, and that's what you make your decision on.
Okay. Yeah. I mean, I think that makes a lot of sense. Again, if you default to this as being a valid patent to begin with, the petitioner should have the burden, and if they leave it out of I don't think district courts allow petitioners to go back. I mean, they do. They allow them to make amendments to the complaint, but there's got to be a reason to do it. It's not just as a matter of course. Oh, I want to address something that's been raised.
And I'm not going to say that the PTAB should have the same iterative process that the district court is allowed to have, because this was supposed to be an efficient, less expensive, quicker alternative.
Well, as you say, I don't think SAS allows that to happen anyway. I don't think it says it as directly as we wish it did, but it seems pretty clear to me the Supreme Court said that this petition the challenge is based on the petition. And you either grant the petition or you deny the petition.
Right.
You can't go and cherry pick it and say, okay, well, I'll take those claims and not these claims. It's the petition, all or nothing. Petition or bust, baby. And I think that then also means that the grounds for the challenge should be in the petition, not in some other document other than the petition.
Yeah. I think it's okay what they're doing now by formalizing discretionary denial briefing separate from the merits. That seems fine to me, but the idea that you can have supplemental briefing on the merits, if you find that your petition now has a hole in it. That just shouldn't be.
Right. And I think the argument that the petitioners have made is, oh, well, we need to do so much in the petition. Well, no, you just got 2 rounds of petition, really. I mean, you don't now in your petition, you don't have to deal with discretionary denial issues. That's something different.
That's right.
So you just got more space in your petition.
Okay, twice as much.
So,
actually.
and if you still don't have enough room and you still need to make your case in chief in a supplemental, I got very little sympathy for that.
Well, they even have the option of filing a second petition to get more words and try to justify that.
Yeah. Yeah. Okay. So next on your list is what?
To presume nexus between secondary considerations and the patent.
So this is about obviousness. So
It is.
and as our friend Scott McEwen has said repeatedly, the PTAB is an obviousness court.
He does say that.
And you agree, I think? I mean, their decisions on invalidity are always 103 based.
90% of the time they are. Now there's some anticipation grounds in there too, which are interesting, but it's mostly obviousness.
So secondary considerations matter in a way that they don't always matter in other forums, I guess, because this is an obviousness court more or less, and if there are secondary considerations, then the patent owner wins. So it seems to me that
it might not be automatic.
Well, no, but I'm going to push back on that because I almost think if you look at the decisions that are made by judges, if they decide there are secondary considerations, they've already kind of decided that it's not obvious. And if they decide that it's obvious, they will not find secondary considerations. Or if they do, they'll be very weak at best and that sort of thing.
Result-oriented decision maker, Gene.
Well, but
I don't know.
Okay, so yes, and I think that's exactly what happens with obviousness, right? I mean, to believe we have an objective obviousness standard or test, I think it's fanciful. It's subjective. It just is.
So,
and the Federal Circuit, to their credit, for 35 years, had created as objective an obviousness test as you could have with teaching, suggestion, or motivation. And it's the Supreme Court that came in and said, no, this needs to be subjective. And they didn't say that, but that was the net result.
Remember that the official name of secondary considerations is objective evidence of non-obviousness.
Right. And they do really matter. And and you've been here. We do a PTAB program every year. You've heard the PTAB judges say this over and over again, that people don't put in enough time and energy in secondary considerations. And I think to myself, well, maybe that's because the patent's supposed to be presumed valid. And it just seems to me that they twist this. And I know what you want to do is say the presumption should be on the side of the patent owner. And I hear and I listen to what the PTAB judges say, and they say, well, the patent owner hasn't proved secondary consideration. I don't think it's for the patent owner to prove anything. I don't think the statute requires the patent owner to prove anything. I don't think the Supreme Court decisions require the patent owner to prove anything. And I think that's what it means, that even though they won't have a clear and convincing standard like you do in district court to invalidate, it's still a presumption. And the patent owner starts at 51%. So it's the petitioner that should have, and I think legally in writing, has the burden on everything.
And, very often the petitioner does already know about the existence of the objective indicia of obviousness. But as it stands, they don't address that in the petition. And if it comes out in the patent owner preliminary response, they're going to get the petitioner is going to get supplemental briefing on that. And they're always, the first argument is they didn't show nexus. And experientially, representing people before the patent office for more than 3 decades, it feels like they have a no nexus stamp. And examiners have it, and I know the judges they're a little more subtle, but they
have it too. I'll say it. and the thing is, and I okay, so I get it on one level. right? You know, because I do think a lot of these PTAB judges are just trying to call balls and strikes as they see it, and we can disagree with that, what their decisions ultimately are. But if you don't start with the belief that the patent owner has a valid, non-obvious claim, then the first person who raises the nexus or the secondary considerations argument, the board is putting on that person the duty to prove it. So the petitioners just ignore it. The patent owner raises it and says, hey, I got secondary considerations. Oh, well, you didn't prove it. But I don't have to prove it. That's what the patent is supposed to be. The patent is already supposed to be proof that this is non-obvious. So it would seem to me that if the petitioner doesn't challenge that, then the fourth factor has to be weighed in, not just presumptively, but in every case in favor of the patent owner. Because it seems to me that the petitioner is the one that has the ball and chain, the burden, to prove all of the elements. So if you don't submit any argument on one of the elements, well, that automatically has to be in favor of the person who has the right. That's what the statute seems to say, right? The petitioner bears the burden of the challenge, not the patent owner.
Now, a somewhat more modest proposal is to require a burden of production on behalf of the patent owner and then keep the burden of proof on the petitioner to prove that that evidence is no good or has no nexus.
Yeah, I guess. I'm going to push back on that just because I don't like it. And the reason,
well, I don't like it either.
The reason I don't like it is it just seems like that, that's sort of, namby-pamby. But I can hear what they're saying. What they'll say is, oh, well, the patent owner is in the best position to have the evidence to demonstrate that there are secondary considerations. Well, the patent owner, up until you filed this, had a valid, presumed valid property right. So I don't like the idea about burden of production. I think the petitioner should be the one that bears the burden on all aspects. It doesn't change the fact, in my mind, that the patent is supposed to be presumed valid, and you're coming to challenge it. So I think burden of production and the burden of persuasion should be on the petitioner. I realize that's not how it plays out. So what's next on your list?
Yeah. So the next one on the list is 325D. And for this, I got to credit my partner, Mitch Yang, who identified this for me to talk about today. Yesterday, at the board side chat, the PTAB management confirmed that the director would include 325D as part of the discretionary denial process that she is putting in place. But what the PTO has never done is, when evaluating 325D, that is whether similar prior art and arguments have already been considered, they've never given credit to the examiner. Unless the examiner and the applicant had a back and forth, which basically consists of a rejection by the examiner over the same prior art that was then argued against and overcome by the applicant. But the language of 325D is that the PTAB can refuse to institute where a similar issue or reference has already been presented to the office. That's the word, presented. And you know what you do when you submit a Form 1449, an information disclosure statement listing a whole bunch of references? You're presenting those references to the patent office. And the patent office has said at the board, well, that's not good enough. It has to be also considered. Well, then, let me finish. Yeah. What happens next to your 1449 IDS form is that the examiner looks at all those references and signs off each one and says, this is considered. They use that same word that the PTAB is demanding for 325D credit, but they don't give them 325D credit.
Yeah. Yeah, there's a lot there. I mean, because the examiners will consider a lot more than what people think they consider. The fact that an examiner actually mentions it in the office action or, in the old days, they put a star next to it, that doesn't mean that they didn't consider other things that you submitted. They looked at it, they didn't think it was relevant, so they didn't spend time on it.
Right. And you know what? The examiners, they're not even given credit for the references that they find and they specifically list as being relevant on the 892 form that they can attach to an office action. So these are references the examiner has located, specifically picked out, specifically identified on the record as having been considered as being relevant, and then they still issue the patent. But the PTAB doesn't give them credit for that as having been something that the office has already considered. And I don't get that.
I don't get it either. It just seems that's an easy fix, it seems to me.
I think it should be. It's been this way ever since the dawn of AIA, but I think it should be fixed.
Yeah. Okay, so the next one relates to VLSI and Opensky.
Yeah.
That's a controversial case. What do you want to do there?
It is.
Stop fraud?
Yes. Stop fraud.
Fraud bad.
Fraud bad.
Okay.
And so, quick catch up. Opensky was found to have engaged in extortion against the patent owner, VLSI. VLSI and Intel were in litigation. Intel filed a petition at the PTAB, but they were too late. It was denied for I think it was fintive. And then so this new company was formed to make a profit, and they first went to Intel and said, "Hey, I got this petition I can file if you cut me in on a little bit on your thing, because it's too late for you, but it's not too late for me." And Intel told them to go pound sand. And then Opensky went to the patent owner and said, "Hey, you know what? I got this petition that I'm going to file against you, and I could. I've already filed it actually, but if you pay me, I will do a Chicago White Sox say it ain't so Joe kind of movement. I will lose on purpose."
And the way they were going to do it was they were going to not pay the expert who wouldn't show up, and then they would agree that without an expert, they had no basis for the case and dismiss it.
Right. So that's all the background. It's been well trodden, but here's where my suggestion comes in, because Director Vidal, when addressing it, she, to her credit, laid all of this out and said this was very, very bad behavior. And I, Catherine Vidal, am going to put the maximum possible penalty against this behavior. And that maximum possible penalty is to take Opensky out of the case, substitute Intel, who was time barred, and let them come in and now have an IPR that they never could have had before but for the fraud. Now, her decision that is the maximum penalty was just legally incorrect. The maximum penalty is to terminate the IPR. That's what should have been done, and my proposal is that's what should be done today. It's still going on. Mm-hmm. And the PTAB, the PTO, has the opportunity to do this because they have an upcoming intervener's brief due at the Federal Circuit, and I think they should confess error on behalf of the last administration, of course.
Right.
And say, we were wrong when we said that the maximum penalty was to switch parties and put the more capable challenger in as the party, even though it was time barred.
So, and it's even worse than that, I think, right? Because Intel was allowed to be a part of this case in the first instance because although they were time barred and could not have filed the IPR themselves directly, once Open Sky files the IPR and it gets instituted, they were allowed to join.
The statute allows that. I think it's wrong, but the statute allows it.
Yeah, and that's got to get fixed. And if it's a statutory fix, then it needs to be a statutory fix. If there's anything that can be done in the rules, then it has to be done, because and I've asked people, I don't know any other situation in law, nobody's been able to give me an example of a situation where somebody is time barred, but then they're allowed to litigate the case anyway. It's the straw man. And, so now we effectively don't have a time bar. If you can go out and hire one of these entities that, the aggregating challengers, we'll call them, that have all these members, they can file when one of their members is time barred. Then if it get instituted, then the member who is time barred, if they want, can parachute in. There's a cottage industry there. Maybe we should just start doing that. I mean, there's probably a lot of money in that, I would think.
That's not an industry I'm interested in getting into.
No, I know. Me either. I mean, having a conscience is really getting in the way of making money sometimes. But
that's okay.
All right, so that's VLSI. There is opportunity still to do the right thing, and hopefully the PTAB, or not the PTAB, but the PTO will do that.
There is. So there's two things they can do, I think. One was to confess error in the upcoming Federal Circuit brief. Another is, I believe, that Acting Director Stewart can issue an order terminating the IPR now. Mm-hmm. Now, the Federal Circuit will be kind of mad that they spent some time and then they got a rug pull, as they say. But I think the PTO can and should do both of those things to make sure that this injustice is rectified.
Yeah. Okay. Good.
But you mentioned about the aggregating organizations. Why don't we talk about those?
Sure.
So right now there are, the famous parties the famous aggregator parties are RPX and Unified. There might be others where they charge a membership fee to various companies, usually big tech companies, and there's a little subtle issue whether they can both, the party and the aggregator, can file their own IPRs and get around the restrictions on serial, time-barred, possibly, IPR petitions where you say the party does an IPR and they lose, whether because they're time-barred or because their merits weren't any good, and then the organization that they pay fees to can come in and say, "Oh, we noticed that. We're going to file a fix-it petition, and we're a different party." And there's no requirement now for for either the party or the aggregator to say that one is a member of the other. We had a case that was kind of famous, Applications in Internet Time, where we did get the challenge of Salesforce terminated by showing that it was a real party in interest with RPX, which had already filed and lost a challenge. But the only way we were able to do that is because we had excellent discovery from the district court litigation, which you're not always going to have. And so my proposal is to require disclosure by the second petitioner of membership in the organization.
I have written about this RPI issue a lot, and I just find it mind-numbing that there hasn't been a solution for it, because real party in interest means something. It goes back hundreds of years. Judge O'Malley wrote in the Application of Internet Time a decision that matched what my understanding was about this all along, even quoting basic civil procedure treatises on what real party in interest means, and laid it all out there. And it doesn't seem to me that anything changed. And it's extremely frustrating. And then, but what I have been told by these aggregators is the folks who have memberships and then they challenge on behalf of the membership, that they are required to disclose their members, and they do it in every petition that they file. And when I was told that, I'm like, oh, really? I must have missed that because I've never seen a list of your members. It's like, can you just send me the list or tell me which IPR that you did that in, and I'll just go and I'll find it and I'll download it.
Yeah.
And they got indignant and got, well, why are you giving me the Inquisition? Why are you giving me the third degree? It's like, well, because, and I didn't say this directly, but it's because I think you're lying. I pay attention to stuff. I've never seen a complete list of members, and I don't think they're required to do it, and I don't think they do it. Am I wrong?
They're not required to disclose a complete list, and they do not do it. That's for sure. And
how can that possibly be legitimate? How could you possibly know who the real party in interest is and whether or not somebody's getting a second bite at the apple if you don't know who are the members of these groups that are challenging on behalf of their members?
So your proposal is to require them to list publicly all members. Mine is a little bit more modest, which is that when one of these membership organizations files a challenge at the PTAB, that they have to disclose if any of the previous challengers are members of their organization.
Yeah, I mean, I suppose, I just think that given the gaming that we know that goes on in this, I think you only get one bite at the apple. That's in the statute, right? I'm not making that up, right? That's actually in the statute. I can't. So like, for example, I can't be a parent company and challenge and then have one of my subsidiaries challenge if I lose, right? I'm supposed to be stopped. Well, if I lose, I'm supposed to be stopped, right? So I think it should be going back to where I was before with, the burden is on the petitioner. The patent owner, it's like when we were kids playing King of the Mountain. You, petitioner, are trying to knock me off the mountain. Well, you knock me off the mountain then. But in order to do that, you have to hit certain metrics. You have to do certain things, make certain proofs. And I think one of them very basically should be, oh, I'm not stopped.
Okay, they do have to say that, but they don't have to provide any information supporting it.
So, but simply requiring that it be said is very different than actually, because the thing is you may think I'm not stopped. I've got an argument. I'm the parent company. This is a wholly owned subsidiary. We're totally different.
Yeah.
But legally we know that that's not the case. If you're a wholly owned subsidiary of the parent, you are the parent, and the parent is you. And I just feel like and this goes back to litigating. I did a lot of motions and discovery practice, for the whole firm. When I was a litigator, I was in court all the time. And it's my job to make my case. And if you have the information I need, I should be allowed to compel you. I should get that information. And this is one of those cases where I can't possibly know who your members are. You know who they are. So why not just tell me? Why not prove that you're not stopped? Just saying I don't like it.
Something needs to be done.
I think something needs to be done there.
Right.
Long past something needing to be done. I can't believe we're so far into this and we still don't have who is a real party in interest sorted out, particularly after Judge O'Malley's decision. It lays it all there. It lays it all out.
Yeah, well, there may be a circuit conflict there.
Yeah. All right. So we got a couple more things that we want to talk about. What else here merits our consideration?
The PTAB should eliminate reliance on common knowledge. I'll start with the statute. The statute requires that challenges be based on patents and printed publications, but there's been a nose under the tent, camel's nose under the tent, and pretty much the first hump is under the tent now too, for common knowledge. And so very often now, a petition will say, one of my grounds is claim 1 is invalid over reference X and Y and the common knowledge of a posita. And that's not a patent or a printed publication, but they're getting away with it. And then that's where the expert comes in and puts in sometimes a 300-page declaration we've seen and saying, well, this was all known in our field. And yeah, sure, usually the good ones will cite additional material, But if those additional materials are actually the basis for showing what was known in the art, they should be part of the grounds, not something to support this nebulous assertion of common knowledge.
Yeah, that always bugs me. If it's so common, if the knowledge is so common, why can't you point to something?
Yeah. So we've seen for decades examiners doing that as a shortcut, but judges doing it as a shortcut, I don't think that's right.
Yeah, no, I would agree. And because let's just explain what's going on here, right? The petitioners are doing it that way because they want to defeat the page limit, right? They have a certain limit, and is it a page limit or is it a word count?
It's a word count.
Word count.
I have a slightly different theory than that, Gene. Because they do have limits against incorporation by reference, and you could go that route if they are really doing that, and there might be some of that. I think that's probably half of it. The other half is that there's a perception, I think a misperception, that if you have too many references in a ground, it's going to seem like, oh, it must be obvious if you have to combine 3, 4, 11 references. And so you do 2 plus the knowledge of a posita, and then the expert says, oh, well, that knowledge comes from these other 8 references.
That you're pushing my buttons when you're talking about obviousness in this way, because if you go beyond 5, and even 5, but you go beyond 5 references to combine to demonstrate that the claim is obvious, I think that's an admission that it's not obvious. And I know legally there's no limit to what you can do, and I know we've seen cases at the PTAB where they've combined 8, 9, 10 or more references.
More.
And to me, that is unconscionable. Everything is a combination of everything that's come before. That's just the way that things work. So if you can just string together an endless number of references and then say, oh, yeah, somebody of skill would know this, and they know this, and they know this, and they know this, and they know this.
You know, I think it depends on what the references are, how closely related they are, how closely the suggestions are to each other. Sometimes you might have 3 papers in the same academic series or something that you could almost read as one, and that's another trick.
Oh, yeah. Okay.
Petitioners do to call it one.
And I get, okay, so and I get that that's why they don't want to have a concrete number on the number of references, you know, because like somebody's magnum opus, it may be published in 3 different pieces, but it's really one work. Okay, well, I think we're adults. We can sort that out. We can figure that out. But it feels to me like, and not just in our area of law, but all through law, what we're doing is we're basing rules and regulations based on the extreme outliers, the 0.01% of the cases. Oh, we can't have that rule because it would eliminate that. So we're going to subject all 99.99% of you to this idiot rule that makes no sense in all of these cases, because it could possibly theoretically make sense in the outlying case.
Well, let's at least eliminate the subterfuge by saying you can't rely on knowledge of a posita as another reference and then, you know, bring in like 10 more for that.
Right. I agree. I'm on board with that one. What else do you have? Serial petitions, are they still an issue?
They are. There's a procedure now at the PTAB where if you're going to file either multiple in parallel or multiple petitions serially, you have to file a separate paper. Well, you're supposed to file a separate paper. They actually don't enforce it. Sometimes they just ask you to put one in. I think it should be a rule that you have to put it in. It's a should. You should put in a paper justifying the use of multiple petitions against the same patent. But my point is that it should go further. The requirement to justify multiple petitions should go beyond just the same party and the same patent. It should go to other parties. Like if this patent has already been challenged by 4 other parties, I think that it should be incumbent on the 5th challenger after it's been upheld 4 times to say, you know, why they should be allowed to do it another time. And I think it should also be expanded to re-exams. If one of those prior challenges was a reexam, I think that should count. And
Well, of course it should count. I mean, it's the office. The office is re-looking at this.
and I think they should transport this this requirement over to the central reexamination unit to require third-party requesters to do the same thing.
Yeah, there's a bunch of streamlining that needs to go on in the after allowance area. I know there's a different standard to start re-exams. There's a different standard to start a PGR. There's a different standard to start an IPR. I think we're just kidding ourselves. They're not different standards. They're different words used by a decision maker to justify wanting to start a re-exam, wanting to start a PGR, or wanting to start an IPR. And I don't think anybody, if you really gave them truth serum and you put bright lights on them, nobody could articulate really what the difference is. That goes beyond just mimicking what the standard is.
Yeah. So this is amusing. At yesterday's board side chat, in response to a question, as you might imagine, PTAB management had a little bit of difficulty enunciating what was the difference between compelling merits, which no longer counts, and strong merits, which does count.
Right. I mean, because they're not different.
Right.
They're just, these things are not different. And I get, and I get that with IPR and PGR, they're in the statute, so the board has to use them, has to use that language. But I think it's important for people to actually fundamentally realize that these are just words that have no meaning. Is it probably different? Is it likely different? Is it substantially likely that one of the claims? Is it reasonably probable? Is there a substantial new question that we need to look at?
Gene, are you okay? You sound like you're just babbling words.
Yeah, I'm just babbling words. This is the word salad version of patent law. It's just ridiculous. It's just ridiculous. It needs to stop. So
now, getting back to serial petitions, I want to give Acting Director Stewart props because she did bring in the concept into the discretionary factors of prior petitions by other parties against the same patent. So that's going to be something that can play into discretionary denial. So I give her props for that. I think it should go a little further, like I said, and require the petitioner to justify it.
Mm-hmm. Okay. So in the other suggestions you have, I know we've gone on for quite a while here now, but the other suggestions that we haven't, I know settled expectations is on your list, which we talked about throughout all of this. We probably don't need to talk about that separately. But there's Congress needs to get involved, and then there's what do we do about the Federal Circuit? Because it seems like they overwhelmingly side with the patent office unless the patent office ruled in favor of the patent owner. And it just seems that if the patent office rules in favor of the patent owner, the Federal Circuit is very likely to overrule the PTAB.
Yeah. So there's one thing that we need to do to reduce the pain to everybody from the interaction between the PTAB and the Federal Circuit, and that is to, and Director Stewart can do this with the stroke of a pen, require the APJs to do what SAS told them to do and decide all grounds when they have a trial. They don't do that. What they do is they find one that is sufficient for them to say all your claims are invalid. Therefore, we're not going to talk about the other grounds, as if they're a court of last resort, which, as we know, they're not technically. So sometimes what you get is in this efficient, shortened process, you get one ground decided and one ground appealed to the Federal Circuit, and 2 or 3 years later the Federal Circuit reverses and says, okay, that ground is no good. Take it back, PTAB, and do one of them other grounds you decided you didn't have time to decide. Mm-hmm. And then that starts another 3-year process. Right. And that's just wrong. And I want to tell you, we have a case right now pending where that's going to be decided. It's MyPac versus Samsung, and I represented MyPac, so I'm a little biased, perhaps. I think we should win. Should be a a reversal without a remand to decide the grounds that the board did not reach.
So are you making the argument that SAS says you have to decide the petition? You only decided one piece of the petition, so you don't get to go back at a second bite of the apple for the rest?
Right, and essentially, my argument pending at the Federal Circuit is that the Federal Circuit should not, or perhaps cannot, remand to the board to address another ground that it hasn't been decided yet, because it's beyond their 1 year limitation. In fact, it's beyond the 1.5 extended year limitation that the board has to decide grounds.
So that's good. That'll be a good case, a good decision, because I obviously think you should win, but if you don't win, that will be something that we can then use and say, look, there needs to be rules written for this. There needs to be an amendment to the statute. Maybe something like that can get into prevail.
I don't think the AIA ever would have passed if the Congress had known that the process was not 12 months long, not 18 months long, but 18 months long plus a 2-year appeal plus another 18-month trial plus another 2-year appeal.
This was supposed to do away with that, right? I mean, because this was really fundamentally to get rid of inter partes reexamination, which took 6, 8, 10 years.
Yeah.
And now what you see is in some of these cases where if the PTAB gets it wrong, it takes 6, 8, 10 years. In between the PTAB taking their time, then the Federal Circuit taking their time, then getting back in front of the PTAB. And when you've gone back in front of the PTAB for remand, you know you're going back up to the Federal Circuit again.
Yeah.
I mean, and all the while, the patent owner who was supposed to have a valid, presumed valid right is stopped. This is a wasting asset. This is not a piece of real property. We should have stronger rights than exist with real property, because real property will exist forever. A patent is a wasting asset. It will be gone. It will vanish. It disappears at some period of time in less than a generation, and often way less than a generation based on when you originally filed and when things get issued. So, all right. Well, we've gone through an awful lot here. We've given the office, I think, a lot of guidance for free. Call us. We've got more ideas. We're there to help if we can. But in the time that we have remaining, is there something that you want to put an emphasis on or an exclamation point on?
Yeah, so now that we've fixed all of the executive branch problems, and you mentioned the Congress, they need to pass, restore, and para. We need to get to the judicial branch, the Federal Circuit in particular. Mm-hmm. There are, it just so happens that the 2 oldest active judges in the entire country are on the Federal Circuit. So at some point, they're going to take senior status and no longer be active, and there will be vacancies. And I don't know how long that's going to take, but I do believe that President Trump, having already nominated some terrific people in the executive branch and in the judicial branch for patents, will be able to fill vacancies well. There's a perception that the Federal Circuit is more inclined to find patents invalid than valid. It's different. And on that ground, I want to state, I'm going to go out on the record here, that we are at an epochal, or at least a generational, turning point on rights and strengths of patents. This is an optimistic view you might not agree with, but I'm convinced of it. First time when I was first hearing about patents, 1982, 1983, that was a low point for patent rights, the nadir, if you will, the low point before the Federal Courts of Improvement Act created the Federal Circuit. And for a while, the Federal Circuit did what they were supposed to do. They strengthened patents, and they did it in a way that was consistent. And then taking us all the way to 2006, the patent strength got higher and higher. You could argue it got too high. But in 2006, eBay came along, and then since then, it's been down, all the way to 2024. You heard it here first. 2025 is the bottom of that long Kondratiev wave.
So you're calling the bottom.
I'm calling the bottom.
Okay.
Oh, I took a survey at your last conference. Nobody chose the option that this was the bottom. Almost everyone said it was too early to tell, but I say this is the bottom.
Well, I hope you're right, because that means at least we've stopped falling.
And here's why I say it. The Federal Circuit can't get any worse. The statutes can't get any worse. And the executive branch is getting better.
You know, for your lips to God's ears, hopefully this is the bottom and it's up from here.
Now, part of the reason I said I can't get any worse at Congress is that the only bills that are under real consideration are patent strengthening bills.
Yeah, there's a lot of other issues that I think are going to take the collective Silicon Valley eye off of patents. That, coupled with what you just said, maybe you can convince me that we have achieved the bottom.
And in the judicial branch, I don't see how it can get any worse either. And as I mentioned, it seems likely that there could be vacancies at the Federal Circuit within the Trump administration, and he appoints good people. For example, at the end of his first administration, he nominated an APJ, Grace Oberman, to be a judge on the Court of Claims. Now, she didn't get a Senate confirmation hearing before time ran out, but at least she's already been vetted, and we know from her APJ jurisprudence and her Department of Justice experience that she would be a good choice for the Federal Circuit.
Yeah. I mean, Judge Oberman, it would be fantastic. And she also happens to have a background in some ways that's very similar, at least technically speaking, to the two oldest judges on the Federal Circuit.
That's right.
And there will come a point in time, just, you know, I don't like to talk about these things, you know, but there will come a point in time when they're not there. I would like to see more patent people on the court.
Yeah, that seems, I don't know, maybe I'm biased, but that seems to me to be the most important thing that they do, is patent stuff. So, yeah, let's have people who are knowledgeable about patents be judges up there. And so much of their docket now is appeals from the PTAB. Why not have a PTAB judge? They now finally have one district court judge among the 12 of them. Why not also have at least one administrative patent judge from the PTAB among them to contribute to the overall deliberations?
Yeah. Well, good. Well, thanks for being here, Jim. I think this was a fascinating conversation. I really appreciate it.
Absolutely. Thanks for having me, Gene, and thanks for everything you do for the innovation community. You are an important voice in this country.